No police can seize your driving license. Section 19 of the Motor Vehicles Act empowers the licensing authority to disqualify from holding a driving license or revoking such license. Thus, under the legal provision, only a licensing authority can suspend or revoke a driving license. So, police do not have any jurisdiction to suspend the license. With the relevant act and rules made thereunder will indicate that a driver of a motor vehicle is always obliged, while driving a vehicle, to keep the driving license with him and to produce the same on demand by any police officer in uniform or by any other appropriate authority on the spot, and his failure to do so would amount to an offence under the provisions of the Motor Vehicles Act, but his failure to produce the insurance and registration certificates on such demand on the spot would not amount to an offence, as he will be entitled to 15 days' time for production of the same before the appropriate officer, and only his failure to produce the same within such time would amount to contravention of the provisions of the Act. Section 158 of the Motor Vehicles Act 1988 provides that any person driving a motor vehicle in any public place shall, on being so required by a police officer in uniform authorized in this behalf by the state government, shall produce the certificate of insurance and registration and driving license, and, in the case a transport vehicle, also the certificate relating to use of the vehicle. It also said that, subsection 3 of section 158 provides specifically that no person shall be liable to conviction under subsection 1, or subsection 2, by reason only of the failure to produce the certificate of insurance, if within 7 days from the date on which its production was required under subsection 1, or as the case may be from the date of occurrence of the accident, he produces the certificate at such police station as may have been specified by him to the police officer. So it is crystal clear that appear from the aforesaid provisions of section 158 of the Act that non-production of the insurance certificate on demand by a police officer will not amount to an offence within the meaning of the said provision, if the same is produced before the police officer within 7 days from his demand or date of accident. It is clear that if at any point of time a driving license is to be seized on the apprehension that the alleged offender may abscond or may avoid service of summons on him, the authority seizing the license shall be at liberty to do so, but only upon recording proper reason therefor and not otherwise. And thereafter he can take necessary follow-up action in terms of section 206 of the Act and Rule 10(2) of the West Bengal Motor Vehicles Rules, 1989. The power of seizure by a police officer of the license of the driver under subsection 2 of section 120 is neither absolute nor can be exercised arbitrarily. That the power of the police officer under subsection 2 of section 206 of the Act cannot go together with the power of the police officer to issue compounding slip under Rule 239(4) of the West Bengal Motor Vehicles Rules 1989, inasmuch as if an accused expresses willingness to have the offence compounded, the fine may be realized then and there from the accused, and under such circumstances question the accused of seizure of his license under section 206(4) cannot arise. Counsels of all the parties have submitted before this court that in view of the importance of the present judgment, which will concern drivers of all non-transport vehicles as well as the police officers who will be on traffic duties, Commissioner of Police, Deputy Commissioner Police Traffic, Additional Commissioner of Police Traffic, Joint Commissioner of Police, and all other authorities entrusted with duties of traffic control, including the officer in charge of traffic guards, North, West, South, East and Central Calcutta, are directed to act in terms of this order. Section 206(2) in the Motor Vehicles Act, 1988. Any police officer or other person authorized in this behalf by the state government may, if he has reason to believe that the driver of a motor vehicle who is charged with any offence under this act may abscond or otherwise avoid the service of a summons, seize any license held by such driver and forward it into the court taking cognizance of the offence, and the said court shall on the first appearance of such driver before it, return the license to him in exchange for the temporary acknowledgement given under subsection 3. Section 206(3) in the Motor Vehicles Act, 1988. A police officer or other person seizing a license under subsection 2 shall give to the person surrendering the license a temporary acknowledgement therefor, and such acknowledgement shall authorize the holder to drive until the license has been returned to him, or until such date as may be specified by the police officer or other person in the acknowledgement, whichever is earlier. Provided that if any magistrate, police officer or other person authorized by the state government in this behalf is, on an application made to him, satisfied that the license cannot be, or has not been, returned to the holder thereof before the date specified in the acknowledgement for any reason for which the holder is not responsible, the magistrate, police officer or other person, as the case may be, may extend the period of authorization to drive to such date as may be specified in the acknowledgement. Hope you like my video. Smash the like button and click on the bell icon so that you can see me more.